Hello friends, in the series on income tax cases, today we will discuss a very important case on section 149 and 148 which talks about the period to issue the notice under section 148. The issue before the Honorable Delhi High Court in the present case was that whether the notice under section 148 is to be issued within 7 days from the last date to give the reply to the notice to section 148A clause B, or from the 7 days when the assessee has filed the reply to the notice under section 148A clause B. The issue has been decided by Honorable Delhi High Court in the case of Shailendra Nath Rai versus Assistant Commissioner of Income Tax in a writ petition. The case is reported at 187 taxman.com 14 and the date of the judgment is 29th May 2026. The assessment year involved is 17-18. The notice under section 148A clause B was issued to the assessee on 29th March 2024 to give reply to that notice up to 8th April 2024. The assessee sought the adjournment 2 times on 8th April 2024 and 12th April 2024. The assessee filed the reply after taking 2 adjournments to the notice under section 148A clause B on 21st April 2024. When the assessee filed the reply, then the assessing officer issued the notice to the assessee under section 148 on 30th April 2024. The assessee filed the writ petition in the Delhi High Court by challenging the notice on basically 2 grounds. First of all, it was the viewpoint of the assessee that the case of the assessee pertains to the assessment year 17-18 and the 6th year from the assessment year 17-18 ends on 31st March 2024, and since the notice under section 148 has been issued on 30th April 2024, so it is time barred. For this, the revenue relied on the case of BKR Capital Private Limited versus ITO, in which the issue before the Honorable Delhi High Court was that if the proceedings under section 148A clause B starts before 31st March but concludes by issuing the notice under section 148 after that, so in that case the notice will be valid. So on this ground, the Honorable Delhi High Court was not with the assessee, but the assessee also challenged the ground on the second part by saying that according to 5th and 6th proviso of section 149, after excluding the time which is given to the assessee to give the reply to the show cause notice under section 148A clause B, or after giving the reply by the assessee to the show cause notice under section 148A clause B, the notice under section 148 is to be issued within 7 days from the date when the assessee has given the reply to the notice under section 148A clause B. Since in the present case the assessee has given the reply on 21st April 2024, so according to the assessee, the last date to issue the notice was 28th April 2024, and since in the present case the notice under section 148 was issued on 30th April 2024, so it is barred by 2 days. When the court heard the matter, the court was of the view that in the present case the notice is clearly barred by limitation by 2 days, because by excluding the period which is given in 5th and 6th proviso to section 149, the assessing officer should have issued the notice up to 28th April 2024, and since in the present case the notice under section 148 has been issued on 30th April 2024, so it is clearly barred by limitation. So as far as the first issue was concerned, that the notice is to be issued up to 31st March 2024, the Delhi High Court rejected the contentions of the assessee, but as per the second part of the writ petition, that the notice is to be issued within 7 days, the notice was quashed. At the end of this video, once again I am repeating the name of the case. The name of the case is Shailendra Nath Rai versus Assistant Commissioner of Income Tax, and this case is reported in 187 taxman.com 2014 and the date of the judgment is 29th May 2026. Thank you friends.